attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the NYSE MKT listing requirements. A company seeking to list securities on the NYSE MKT must meet minimum listing requirements, including specified financial, liquidity, and corporate governance criteria. The NYSE MKT has broad discretion over the listing process and may deny an application even if the technical requirements are met, if it believes such denial will protect investors and the public interest. The factors the NYSE MKT consider include, but are not limited to, the nature of a company's business, the market for its products, its regulatory history, its past corporate governance activities, the reputation of its management, its historical record and pattern of growth, its financial integrity, and its demonstrated earning power and its future outlook. Once listed, a company must meet continued listing standards. In order to apply for listing on the NYSE MKT, a company must complete and submit a listing application, including specified documents and information. The NYSE MKT has 4 standards available for listing that you can qualify for. Each standard considers certain factors, including pre-tax income, market capitalization, the market value of the public float, a minimum bid price, operating history, shareholders' equity, the number of public shareholders, and number of shares in the public float. Generally speaking, a company must have a minimum of $4 million in shareholders' equity and a minimum bid price of $3 to qualify for the NYSE MKT. In addition, a company must have 400 public shareholders and either 500,000 or 1 million public float shares, depending on the standard of qualification. Depending on the standard used, a company must have either $750,000 of pre-tax income for the last fiscal or 2 of the last 3 years and a market value of public float of $3 million, or a market value of public float of $15 million in 2 years of operating history, or a market value of public float of $15 million and $50 million market capitalization, or a market value of public float of $20 million and a market cap of at least $75 million or $75 million in assets and revenues. Public shareholders and public float do not include shareholders or shares held directly or indirectly by any officer, director, or 10% or greater shareholder or their affiliates or family members. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.